Okay, let's get into private law now. Just checking. Oh, I'm disconnected for some reason. So, private law is all about governing. I know that says 6th grade, by the way. It's definitely meant to be like 6th form for the UK, and therefore us, not like year 6. Private law, as I mentioned, I'm using a very, very broad title, but it's the section of the law that governs interactions between people. So throughout your study, you'll look at things like land law, you'll look at contracts, business law, torts, trusts, all these types of things. Resolving civil disputes, these types of things. Now, that's a pretty broad range, and every subject is a little bit different. Just because you hate contracts, for instance, it doesn't mean you're going to hate trusts, even though it seems like they might be very similar. It's really interesting, this course, as a way of looking at how people are able to get themselves into trouble and how the law will still step in to protect them, I think is a good way of looking at it. So things like people suing the state or national parks or something for a lack of safety, and the government will still be like, yeah, fair, let's make it safer for you guys, even if they've done something objectively silly. And same with things like equity. So, torts is the OG field of private law. It goes back way into like 1100 type stuff. Our initial legal kind of foundation is this. So some of the cases you'll read is like, someone comes up to someone with a sword and says, were it not the day of the Sabbath, I would stab you right now. And it's like, that's so divorced from our current context in so many ways, but it's still a key case that you will rely on. Not to the extent that you'll rely on its relationship to the facts, but that is a case that is about ambiguous threats, basically. Threats that rely on something else, and therefore, well, it's a Sunday, so he's not going to stab you. So therefore, not assault. A tort is defined as a legal wrong that one person commits against another that generally infringes on some type of legal right. Personal liberty, property, interference, these types of things. Generally, the remedy is compensation, as most torts are, or as most civil cases really are. It's about suing another that you have taken X from me, I want Y back. And the important notion to remember here with civil law is that it always intends to restore the victim to their place prior to the event. So it's not necessarily about like getting incredibly incredible benefit out of the case, although in some cases that would be regarding, say, punitive damages and stuff like that. But generally, it's about equalizing the playing field. The remedy, as I said, is compensation. Though, however, some torts, assault and battery, false imprisonment, criminal negligence, can also be governed by the state and may result in further punishment if the breach of care or the events in question can be proven beyond reasonable doubt, which is a concept we'll get to at the end of the lecture. So, I don't know why that needed to absolutely squish the quality down of that image. So you'll go through a couple of different torts in your torts course, but the main one you'll start to study is the tort of negligence. Now, this is a classic case that it outlines it of Donahue and Stevenson. It's from 1932. This is a funny case, and if you ever you'll start to see a bunch of stuff in law to do with snails, especially when you do torts. This is where this case comes from. So Donahue bought a ginger beer from a store. I think. Yes. Donahue bought a ginger beer from a store. She drank it, or as it was being poured out, and then she realized that there was a very badly decomposed snail inside, which is gross. She gets really, really sick. She ends up basically getting food poisoning from the snail in her ginger beer. Now, she wants to sue the manufacturer of the ginger beer. Now, this is a bit hard sue the company that manufactured the ginger beer. Now, this is a bit hard because she didn't have a direct contract with them, so there's no breach of contract. So she didn't go to the factory and buy one directly from Stevenson. She got it from a cafe, and now she could, I guess, sue the cafe for breach of contract in terms of delivering an edible or a consumable product. She wants to try and get compensation from the big guy up the top who let a snail get in the drink and get bottled and get sent away. This case determines that even if there isn't a contract between people, you may still have a duty of care to your neighbours. So we can then see it's very 1930 as it, takes a lead from like Christianity in terms of, caring for your neighbours. But this is the famous section, which is, who then in law is my neighbour? The answer seems to be persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions which are called into question. You must take reasonable care to avoid acts or omissions that you can reasonably foresee would be likely to injure your neighbour. Now, law is very fluffy with its language, so we've obviously got use of like reasonably foresee there. So, i.e., a manufacturer of a drink doesn't have to reasonably foresee something absolutely freakish happening. But you can probably reasonably foresee if the warehouse isn't clean, someone might get sick when they order your food. So this is the principle of negligence and the primary principle of what a duty of care is. This is then expanded through statute, especially for specific duties of care, like between specific classes, like doctor-patient, blah, 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 blah. But this is our main principle that you'll start with. And as you can kind of see, it's very much a iconic line. I remember when I first learned it, I said, we're doing torts at the moment. Donahue, I said to my uncle, who's a lawyer. And he was like, go on, tell me what the line is. And I was like, you got to take care of your neighbour. And he was like, no, what's the words? And I was like, man, I don't know. But a lot of people know these words off by heart, especially if they learned law a little while ago. Now, these memes obviously created at the peak of the pandemic. I was doing torts when the pandemic started. So I was like, remember when this was a thing? My law lecturer showed us something like this because she thought it was very funny. So I figured I'd chuck that again. But yeah, very key aspect. So to prove negligence then, we need to do a few things. We can't just say like, you did a duty, you had a duty, that something bad happened, right? And therefore you should be held responsible. To prove negligence, we've got kind of four main elements. A duty of care, as we saw in Donahue, a breach of that duty. So this can often be hard to prove, and depending on the field, there may be more protection. So for instance, for medical negligence, there's a bit of a higher threshold. And I'll get to that in 2 seconds, so let me just finish my train of thought. So a breach of duty, it has to be a foreseeable risk and an ordinary person would have taken precautions. So as I said, it can't be an absolute freak of nature. Like some massive storm comes and like there's let's say you're in a building, there's a 9-point magnitude earthquake or something and something gets broken. Probably not reasonably foreseeable if you live in Australia. Well, if you live in Japan, maybe, yes. If the risk is obvious, like that's a defense, i.e. that you have willingly accepted a risk as a victim. Now that is sometimes also doesn't work to an extent, so that governs things, certain injuries in sport, for instance, but may not govern like very violent injuries. It's a little bit clunky, that point. So it has to be a breach. The breach has to be foreseeable, but not too foreseeable, but not too foreseeable, so you'll get to that. But the point is that it has to be a breach of that duty outlined in Donahue that a reasonable person would have seen could be a potential. The simple element, an injury has to have occurred as a result, like there's an injury somewhere. And most importantly, that breach caused that injury. So there has to be causation. Now, there are a couple of tests that do. One is the but-for test. But for the breach of that duty, the accident would not have occurred and therefore the injury would not have happened. It's quite a traditional way of phrasing it. But the alternative is there can't be a novus actus intervenius, an intervening act. So, as I said, if there is some type of freak storm, that's probably an intervening act. It breaks the chain of causation and the breach can no longer be connected to the injury that occurs. So one of the famous cases in this regard, and I can't quite remember the name, actually I can't at all remember the name, is a case of, I'm not sure where duty of care comes into it, so it might be more generally causation, is that someone, say, locks someone in a room, there's a window, but it's on the 3rd story. This person is being threatened, they want to get out, they jump out the window, they break their leg, they try and sue the person. The person who locked them in the room is like, okay, cop me for false imprisonment, sure, but like I didn't put a gun to their head and make them jump out the window. That's obviously an intervening act. You chose to jump out that window. Now, obviously, there's still a pretty clear chain of causation there. But for being locked in that room, the person wouldn't have jumped out the window. So that's how you can kind of figure that one out. A case which is it's not topical anymore, but there was a TV show, if any of you saw The Girl from Plainville, what's her name? Elle Fanning played her, which is about the so-called texting suicide case. This kind of tested the notion of causation and intervening acts, and it was said that there was an intervening act, that someone wanted to stop harming themselves and then they were kind of coerced back into doing so, and therefore there was a break in causation. Other torts include false imprisonment and assault and battery. So false imprisonment has some set elements again. The defendant must be restrained directly against their will. So, i.e., there's a positive, involuntary, I think. There's a positive action by the defendant. That should not be defendant, actually. I'm lying. It should be P. Plaintiff. Sorry about that, I got mixed up there. So the plaintiff must have been restrained directly against their will. So there has to have been a positive and voluntary act by the defendant to do so. So the defendant can't have been forced into engaging in false imprisonment, because that's not fair. They're not the mastermind there. And there has to be a positive act. So they can't just be like chilling there and someone goes, hey, you're imprisoning me. The other key thing here is it has to be against their will. And that doesn't necessarily mean, they agreed to it, therefore they went along with it. But if you say engage in this case, Balmain Ferry Co. is the case, where a person had gone in, went to catch the ferry left, they wanted to get out, they had to pay to get out. Now they had clearly entered onto the wharf of their free will. It was no longer false. It wasn't false imprisonment because they chose to be there. The plaintiff must be restrained in a fixed area, i.e. it can't be Australia as a concept. However, it can also be a psychological restraint. You don't have to physically be in a cage. It can also be the threat of a copper kind of watching you on a bench. In theory, you could get up and run away, but there's still that threat there. The other thing is total restraint is needed, either psychologically or physically. Someone standing in your way on a road when they could just walk around you is not false imprisonment. Unless, as I said, there's that threat involved. Battery and assault are also connected. As I kind of mentioned, that they're both in criminal law, just called assault. Battery is actually the physical action of attacking someone. Assault is the threat of attacking someone. So battery, an attempt at battery is probably an assault. A failed battery may still be an assault. First off, there has to be a positive intentional act. There has to be an intention to either threaten someone or be reckless in that nature. or a positive or an intentional like hitting of someone or any other thing. Intentional here, and in most law cases, also refers to, you should have thought that someone would interpret it in that way, i.e. recklessness. You either intentionally did it or you were reckless and you should have known that someone would interpret that as intention. Positive is also quite interesting here, in that it can't just be you're chilling, like someone comes up to you and bumps into you and it's like, oh, you just battered me. However, a inaction can sometimes be a positive act. So there's a case, and as I said, I can't remember the name, because this is way back term 1, year 1, where someone accidentally rolled onto someone's foot with their car and crushed it. Now this person was like, get off me, you're crushing my foot. And they said, nah, and got out of the car and left the car there. Now, initially, the act of rolling the car onto someone's foot isn't necessarily battery. It could be an accident. There's no intention there. The act of continuing to leave the car there, even though, ironically, it's not positive, you're not doing anything, it's positive in the sense that there has been a decision made to do something. In this case, do nothing. Battery is about a positive intentional act that causes contact. Assault is that causes a reasonable apprehension of harm. I'm gonna get you. May be too vague. Actually, there's a case that determines that vagueness is okay if there is that reasonable threat. So that's what those two are. Okay, moving on to another aspect of civil law here. Contract formation. Contract is a formalization of civil relationships. A formalization of civil relationships. You may cover contracts over multiple terms, and it's probably one of the only, I think, subjects that kind of you need to kind of keep the stuff in your brain. With other ones, like with torts, you can, to an extent, you do the subject and then are like, okay, bye, torts knowledge. Contract will come up for a few subjects. So just make sure, keep that in mind. It doesn't mean you have to like work on your notes over the holidays or anything like that, but it is something to remember. Within this subject, you're probably going to be asked a couple of things. Is a contract valid? Was it validly formed? Is there actually a contract? Have certain terms been included correctly? Has there been a breach of contract? What are the consequences of this breach? Our 5 main elements of contract, these being put in brackets because while they're still important, we don't necessarily check them off every single time unless there's an issue. Offer, straightforward, right? There's an offer of, hey, I want to make a contract with you. Do you want to? Is it agreement? Yeah, I'll make a contract with you. There has to be an intention to create a contract, i.e. you can't just sign something and then someone's like, haha, got you, signed it. So, i.e., hey, do you want to make a contract? Yes, I do. I want to make a contract is a good way. That's intention, right? Consideration is where you get a little bit funky. So consideration is also known as the quid pro quo step. Now, what this means is this for that. So you can't just say, hey, I'm going to give you $50,000. That's it. That's for funsies. Do you want to make it in contract of like, I'll give you $50,000? That's not enough. That's not a thing. Now, the consideration has to be kind of equal. Like it can't be like, yeah, sure, I'll give you $1 in return. That is just a gift. It's governed by different principles. Consideration has to be some type of this for that. I will pay you money and you will mow my lawn. I will pay you money, you will give me a gift, like a product. I will order it online. That's all quid pro quo. So it can be service, it can be physical, generally will involve some type of money when you're looking at contracts type thing. There's also certainty, which is both parties are aware they're making the contract and they know what the contract is about. It can't be too vague. There has to be a clearly like, This is what the contract is about. This is our terms. This is our subject. Those next 4 little things: legal capacity, consent, privity, legality. Legality is straightforward. You can't make a contract for something illegal. I mean, you can, but it's not going to hold up in a court of law. Or also you might go to jail. So there are 2 versions of this. Obviously, the first is like, I have a contract for a hitman. Is a problem all around because, you know, not great. The other thing could be, I am going to sign a contract, quite common one. I don't know if you're doing contracts or torts, but it's relevant regardless, about certain amounts of, I've signed a contract here that you get to harm me and I'll enjoy it kind of thing. Now, no. Like you could say that's like a consent thing and it tends to be discussed when we get criminal law, but it's a similar thing. If it's like, I am going to contract you to be my slave, in certain circumstances that might be okay. I'm not going to get into the logistics of that type of stuff. But if it's straight up giving up your rights and possessions for some type of quid pro quo, that's not legal. Privity refers to the notion that the person involved in the contract is privy to the contract, i.e. you can't create a contract about someone else or on their behalf without them being involved. Consent, pretty straightforward. It's connected to privity, right? You need to have consent to make a contract about something. Legal capacity is about the person making the contract involved in that has to be able to be involved in that process. So can't have a child, or can't have people that maybe are not cognitively as well. For a contract to end, we have some basic ones. Performance. Hey, I hired you to mow my lawn, you mowed my lawn, sick, the contract's over. By agreement, you're going to mow my lawn 4 times, and you're going to mow my lawn 4 times. Okay, 4 times have passed, contract's over. Frustration is if something happens that cannot be repaired. You were going to mow my lawn 4 times, but now you've died. Therefore, you can't mow my lawn. The contractor has been frustrated. It basically says, it's fine, it's over, but there doesn't have to be a breach. Spicy ones include repudiation and a breach of contract. Repudiation refers to the fact that one party is unable or unwilling to fulfill their side of the contract. So it might be, I hired you to mow my lawn. I have a contract with you to mow my lawn 4 times, but you are going bankrupt. You do not have the ability to fulfill your side of the contract. I'm going to repudiate this contract. Breach is, I have a contract for you to mow my lawn 4 times and instead you've painted my house, for instance, maybe, which is a bit silly, but that's okay. The breach has to also be sufficiently serious for it to rise to it. So if it's, I made a contract for you to mow my lawn 4 times, and it's I've mowed it 5 times maybe? No, maybe not. 3 times, and I will come back in a month because I'm going on holidays. That's probably not a really serious breach of contract, unless it says in the contract you can't go on holidays or something like that. The remedy for contract law is about loss. As I said, most private law attempts to put the plaintiff in the position they were before whatever happened, with the exception of punitive damages. So there is loss of opportunity and general loss, which is just regular damages. So that includes, I gave you money and now it's gone, give it back to me. Or I entered into agreement with you and you said you were going to get me heaps of exposure, which would have amounted to $50,000 down the track type thing. There's also specific performance and injunction, which are equitable remedies, which we'll get to equity in 2 seconds. Now, what that means is specific injunction stops you from doing something. A specific performance makes the other party fulfill their side of the contract. So i.e., I don't want my money back, I just want you to do it. Or alternatively, they have no money and they still just need to do it. Rescission is a way of basically stepping back to the beginning and undoing the contract from the very start. Saying, okay, we're setting aside the contract, it never existed. So there can be no breach because the contract has been disbanded, basically. Equity, as I said, sits alongside private law. It used to be two separate jurisdictions and now it's been merged. So you can simultaneously run a claim through common law and equity. This is about ensuring private dealings are fair. So if you have a contract and the contract, there's been no breach in that regard, but something is very wrong, that will be when the law kind of steps in and says there needs to be something here. This isn't fair. So some clear areas where this happens is unconscionability and fiduciary relationships. Unconscionability, our famous case is Amadio and Commonwealth Bank of Australia. Now this was the case where a child, and when I say child, like an adult child, got his parents to be the executor on a home loan for him. Or the guarantors, sorry, I should say, on a home loan for him. Now, his parents couldn't speak English, and they didn't really get what they were doing. So he went, yeah, no, it'll be fine. I'll pay back all my loans. Like, don't even stress. I just need our signature. It doesn't even matter. Don't stress. And they signed it. So they were like, well, it's our son. We trust him. We don't know what's going on, but now he defaulted on his loans and Commonwealth Bank came to collect. I don't know if he went bankrupt and therefore they went to the parents and the parents were like, what? Like, I don't know what's going on here. This went to courts and the courts found that while, yeah, technically Commonwealth Bank was within their right to do that, it would be unconscionable because there's a clear disadvantage here that's happening. The other case in fiduciary relationships will be things like you can't derive a separate benefit from a relationship without consent. So if you're running a company with someone and you get some insider information as a result of working for that company, say, I know that a certain area of land has just been bought, so I'm going to open up my own firm or something there. Without my knowledge that I derive from my relationship, I wouldn't be able to be successful. So therefore, unless my boss says, yeah, go set up a new building over there, I've done the wrong thing by that relationship, even though it's technically not illegal. And same thing with being able to make money off of certain ventures where you're using your relationship with someone else or with business or whatever. Trusts you can think of as a bit like a funky contract with some more rules. So trust is about holding property under contract basically for a certain amount of time. What this means is that there are some rules here, and what this means to create a trust is there has to be a certainty of intention, i.e. there has to be, much like in a contract, a clear intention to set up a trust, a certainty of subject, who does the trust involve, a certainty of object, it has to be identifiable, you can't like make a trust of vibes, so what is it that is involved in the trust, and full constitution or valuable consideration, which basically means the person creating the trust has to have legal right to what they're including on the trust, or have engaged in some type of consideration to allow that element of property to be included without their possession of it. Trust, you're probably not going to get to for a little while, so we don't stress too much about this, but I just wanted to chuck it in regardless. So trustees must also obey the trust terms as they are simply holding the trust property for the beneficiary. So then we move on to alternative dispute resolution, which is a little bit of a funky one. What this means is that to solve a civil case or a private case, you don't necessarily need to go to court. Instead, you can go through different methods. Negotiation, mediation, and arbitration are our main ones. And they include negotiation being where two parties meet to attempt to unify their remedies. So basically we have two opposing goals. Let's see where we can meet in the middle. Mediation is a bit like negotiation, but there's a third party that will organize it. Arbitration is kind of like a court. There is a judge-like figure who hands down a legally binding outcome, but it's not public like the court system. So, using those three examples of in mediation, negotiation, arbitration versus litigation, which is the traditional court-based system, why might a company, a firm, a client want to go through alternative dispute resolution, use an alternative method instead of litigation? So I put up a little Slido at the moment that's just a brainstorm. Don't stress if you're wrong, right? Like there is no wrong answer, number one. All your thoughts are very valid. But why do you think it would be worthwhile to use an alternate method to resolve an issue instead of going to court? So just a little bit of critical thinking. And then we're going to go on a break. So I'm going to hold this poll open. I'm going to sit for 2 minutes while I see some responses come through. And then we're going to go on a little bit of a break for about 10 minutes. And then we're going to start on the second half, which is public law and criminal law. But why do you think, and then we'll also discuss the answer to this, obviously. But I'm going to hold for 2 minutes. See if we can get a response. Why do you think alternative dispute resolution might be favoured over general litigation? And if it's a bit difficult, don't stress. We did this in class yesterday. Like me, I did this, sorry, not yesterday, on Monday. We had this discussion. So someone's already said cheaper and quicker. Also private, so the company won't suffer from bad publicity. Nailed it. Pretty good, yeah. It is, sometimes it can be a bit, like, depends on who you like. If you're bringing in someone really fancy to be your mediator, it might be a bit more expensive. But it's generally going to be more efficient than the courts. And potentially we can have that privacy. Faster, yeah, probably. Possibly to save face. The possibility of litigation may involve media parties and unwanted attention, so an outside negotiation may be beneficial. Absolutely. It's a bad look, right? Or it can be a bad look. Less expensive, more time efficient, less media attention scrutiny, promotes amicable relationships. Yeah, that's a really good point. It's a less hostile, maybe not arbitration, but mediation and negotiation will generally be less hostile because you actually get people in the room and go, okay, let's discuss. And can reach a more favourable decision. And yeah, there is a possibility for things, especially like, as I said, mediation and negotiation, that you can kind of get to a neutral ground where both sides kind of get what they want. Whereas litigation will just like, okay, you're right, see ya. So yeah, really good. Really great thinking for the 4 of you that responded. Thank you so much. You can keep having a go if you would like to. So one case I think that's really relevant at the moment is the case of Sally Rugg and Dr. Monique Ryan at the moment. So if you can do a Google for those of you that aren't chronically connected to politics like me. That is a staffer of Dr. Monique Ryan, who's an independent in Melbourne, an independent politician, says that she was unfairly terminated. Now, allegedly, I don't actually know, I can't remember. She filed a claim in, I can't remember what court she claimed, basically wrongful dismissal. Now, that now then went to mediation because of the negative media attention, I think was the main reason, is everyone was kind of going, oh, you know, of course Monique Ryan's like working them too hard, of course she is, when people going, well, maybe she shouldn't have, you know, Sally Rugg shouldn't have gone into politics if she didn't want to work the long hours, blah, 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 blah. Not the point. But there's all happening on Twitter, so it's not like there is a sense of logic going on in this commentary. It was then taken to mediation, I think, where they came to the conclusion that Sally gets to work a bit longer, ran out of time, and then we'll leave or something like that. So it worked out quite well. It had that better outcome and took it out in the media. But yeah, really good job.